Funding for New Mexico in Focus provided by viewers like you.
This week on New Mexico in Focus, hanging in the balance. New Mexicans wait to see if the state Supreme Court will hear a case accusing the city of Albuquerque of violating the constitutional rights of unhoused people.
We're just reminding the city that the New Mexico Constitution applies to people who are experiencing homelessness as well.
And an author's new book explores how 20th century federal law allowed her immigrant ancestors to benefit from stolen indigenous lands. New Mexico in Focus starts now. Thanks for joining us this week. I'm senior producer Lou DeVizio. We're stepping aside from our usual roundtable discussions today for a deeper dive on three topics. This April, Governor Michelle Lujan Grisham signed House Bill 15 into law. It allows immigrants in New Mexico between the ages of 19 and 21 to apply for green cards. The special status also provides other benefits to these young people if they can demonstrate in state court that they have been abandoned, abused, or neglected by one or both of their parents. In the second half of today's show, executive producer Jeff Proctor sits down with two attorneys who helped get House Bill 15 passed. Then later in the show, Our-Land's Laura Paskus speaks with author Rebecca Claren about her new book. About a century ago, Claren's ancestors fled anti-Semitism in Russia to live in America. When they got here, her Jewish relatives purchased land that the U.S. government had stolen from the Lakota people. In just under 20 minutes, Claren explains how she explored acts of reconciliation and repatriation in the writing of her book, The Cost of Free Land, Jews, Lakota, and an American Inheritance. Now, as we record this today, Thursday, October 12th, we're awaiting a decision from the state Supreme Court in a pending lawsuit on behalf of unhoused people in the city of Albuquerque. Late last week, the city asked the justices to reverse a district court judge's injunction barring the city from removing homeless people from public spaces or taking their property. The request comes after civil rights lawyers filed a lawsuit last year accusing the city of violating the constitutional rights of unhoused people living at Coronado Park and elsewhere by destroying their belongings and shuffling them from place to place around the city without notice. Earlier this month, I interviewed two attorneys who filed the lawsuit about their case and what steps the city could take to address homelessness. Adam Flores, Martha Mulvaney, thanks so much for joining me here on New Mexico in Focus.
Thanks for having us.
Yeah, thank you.
Now, your law firm sued the city of Albuquerque on behalf of several unhoused clients over policies and practices that created certain conditions for them and, frankly, for all unhoused people in the city. Martha, what were those conditions and what were your clients and others like them facing in Albuquerque?
So Lou, I just want to say that what this case is about is ensuring that the city of Albuquerque respects the constitutional rights of everybody in our community, and that includes people who have been forced by their economic and other circumstances to live outside because they have no indoor place to live. And we filed this lawsuit because what we learned is that what the city was doing is that it was criminalizing the presence of unhoused people anywhere with their belongings on public property, even though the city knew that these people had no place to be indoors. And in addition, the city was seizing and destroying their personal property, and that included property that's essential for a person's survival. It included clothing, food, medicine, tents, blankets, the kinds of property that we all need in order to live.
And the broader context is that there's a housing shortage in the city, and so there just aren't enough homes to accommodate the number of people who are living in the city. And so as a result of that, there are necessarily going to be some people who have to live outside. And it turns out that the city's chosen method to address the crisis is the most costly and least effective method, which is criminal enforcement. And so what that looks like on the ground is police and sanitation workers will just descend on somebody who's camping outside and then order the person to move. And so people are just being shuffled around the city. Their belongings are being destroyed in the process. And the process just repeats over and over aimlessly without accomplishing anything. And so we brought the lawsuit because the city can make foolish decisions, it can waste public funds, but what it can't do is violate people's constitutional rights. And so we're just reminding the city that the New Mexico Constitution applies to people who are experiencing homelessness as well.
Sure. Now, those policies and practices that both of you just mentioned, are those still in place right now?
They are. The city's continuing to engage in these practices. We obtained a preliminary injunction from the district court, but it doesn't go into effect until November 1st. And so we've heard that the city is continuing to harass and cite people for their presence outdoors on public property and take and destroy their belongings.
Now, your clients won a victory in Judge Joshua Allison's courtroom a couple of weeks ago, and we'll get to some of those details in a bit. You've both mentioned some already, but every lawsuit, of course, has to have a legal basis. Adam, you mentioned the constitutional violations, but from the perspective of your case, what specific policies and practices are violating what specific constitutional rights?
So the core of the case is the New Mexico Constitution's cruel and unusual punishment clause, and the idea there is that it goes back to the housing shortage. There are going to be people who are forced to live outdoors. They don't have access to indoor space. And so when the city comes and responds to that by enacting a web of ordinances that makes it a crime to occupy every square inch of public property, which is what's happened. You can't block a sidewalk, you can't stay in an alleyway, you can't stay in a public park, you can't occupy a public lot, you can't erect a tent anywhere in the city. The result of that is that a person's presence anywhere becomes a crime. And so, one of our named plaintiffs is Sonia Garcia. She recently was fortunate enough to get a hotel voucher, so she was off the streets for a couple weeks. But once that expires, she's back outdoors, living outside, sheltering outside again. And I can pretty much guarantee you, I don't know where she is right now, but I can pretty much guarantee you that she's violating some city ordinance right now because she has to be. And so that raises constitutional concerns for the city because you cannot criminalize a person's existence, which is what's happening. The second set of claims, which Martha mentioned earlier, are related to the destruction of people's property. And so these are real basic, we are all familiar with property rights and our property interests. So, I can expect that I can walk down the street and police aren't going to seize my glasses and throw them in the trash truck, or your pen or your phone or anything like that. But it's a process that's become normalized for people who are unhoused. The city, I think, thinks that their belongings are trash. Doesn't matter what they are, their blankets, tents, their medication, the documents that they need to access services. They're all subject to immediate seizure and destruction on the spot. So ordinarily, there are all sorts of procedural protections that people have from that. You get a hearing before your property can be seized. You have a right to retrieve your belongings after they're seized, or a post-deprivation hearing after your property is seized. The city's practice is not to apply any of those protections to people who are experiencing homelessness.
Now, much of the focus surrounding this case has been on the city's decision to clear an encampment that was at Coronado Park. Now, keeping in mind the constitutional protections that Adam just mentioned, Martha, what happened at Coronado and what specifically did the city do there?
So what happened at Coronado Park is that for a long time, the city sort of passively permitted people to stay at Coronado Park. And then at some point, for reasons that aren't clear, decided that it wasn't going to do that anymore. So although people had developed an expectation that they could stay at Coronado Park safely, the city closed it without informing people that it was going to do that. Instead, the city had a practice of conducting cleanings every 2 weeks, and so it behaved as if it was going to conduct an ordinary cleaning. But what happened is that the city came and started just seizing and destroying people's belongings. And even when people got out of the park and were trying to leave with their belongings, the city seized and destroyed their property that was out on the sidewalk. And then the city closed the park, fenced it off, and flooded it. And of course, the city is under no obligation to provide places for people to be. But if it chooses not to provide places for people to be, then it cannot enforce the criminal law against them.
Now, something that you've mentioned several times, Adam, is something that I definitely want to talk about, and that's the core contention that the city has made it impossible for unhoused people to be anywhere, and that city officials have criminalized a state of existence, as you've said. As Judge Allison put it in his order granting the injunction, everybody has to be someplace. Can you talk about that just from a basic human rights perspective?
Yeah, it really is. I mean, it's, when you think about it in terms of cruel and unusual punishment or the legal standards, it gets a little murky, but the basic right is that you have to be somewhere. And if because of macroeconomic trends, you're priced out of the housing market and you're now being priced out of the rental market and you no longer have access to indoor space, you have to be able to access outdoor public space or else you cannot be anywhere. And so it really is criminalizing people's existence.
Now, of course, there are concerns from residents and business owners about the impact of homelessness on the broader community. What conversation would you like to have, Adam, with folks who would contend that your lawsuit might make this long-standing issue even worse?
Well, I'd really push back against the narrative or the notion that the lawsuit is part of the problem or in any way contributes to the problem, or that the court's order contributes to this problem. This is a problem that the city created. This is a problem that the city can solve. And if this lawsuit went away tomorrow, this lawsuit, which is designed to protect people's rights, went away tomorrow, that would have no impact on the housing crisis. It wouldn't eliminate the housing crisis, and it wouldn't reduce the number of people who are forced to sleep outside by one person.
Now, Martha, why isn't the city's public interest in maintaining safe and clean public spaces enough to justify some of those practices, the seizures, the removals that you mentioned earlier?
Yeah, so the city has tried to make that claim that it has a particular interest in safety and cleanliness related to unhoused people. But what the city's really trying to do is create a homelessness exception to the Constitution. All human beings create trash. Some human beings among every population commit crimes, and the city has constitutional ways to manage those issues. With respect to trash, the city has developed a comprehensive waste management system that works very effectively for people with homes. And the fact that it's chosen not to do that with respect to people who are forced by circumstances to live outdoors is a failure of municipal waste policy. It's not some inherent condition of homelessness. And similarly, with respect to crime, people who live in homes commit crimes, and when they do, the city doesn't clear entire neighborhoods or seize everybody's property. What it does is what it constitutionally is permitted to do, which is develop probable cause as to specific individuals regarding specific offenses and prosecuting them in accordance with the Constitution. And the city can take those same actions with respect to unhoused people.
Now, the mayor told me in May that this litigation was coming to a close. Clearly, that's not the case. What has the city's response been like in court, Adam?
Yeah, I think I actually saw that interview in May, and I think that the mayor doesn't take us seriously and doesn't take this issue seriously, which should be very concerning for everybody who lives in the city. This is not, as I mentioned, when the lawsuit ends, if this lawsuit goes away, that's not going to reduce homelessness. That's not going to solve any of these problems.
Given their posture, what do you think that means for the prospect of policy and procedure changes?
I don't know I really don't know what the city's going to do. I hope that the city looks for proactive solutions, looks for other ideas other than criminal enforcement, but I don't know. I'm not sure what the city's going to do.
I just wanted to add, so of course, nothing about our lawsuit requires the city to take any affirmative steps to solve the homelessness crisis. But having people living outside in tents is not good for anybody. It's not good for the people who are forced to live outdoors. It's not good for the businesses, the residents, the tourists who would like access to those public spaces. And it's not good for the city that's going to have to be handling unhappy constituents. The only solution to the problem of homelessness is housing. And emergency shelters should be for just that, for housing emergencies. For example, if a person has to leave her home because of domestic violence, or if a person loses his employment because of an illness and is evicted, we need emergency shelters for housing emergencies. And in the meantime, if the city doesn't want unhoused people just living all over the city would do well to create spaces where unhoused people who are forced to live outdoors can be and provide services. All human beings need access to toilets, they need showers, they need laundry services. And those kinds of services would make it possible for housed people and unhoused people to live more comfortably in the spaces that we share.
Now, a lot of our viewers will be familiar with big court cases that resulted in consent decrees, reforms in conditions in jails, prisons, police reforms. Adam, what comes next in this case, and is a long-term court oversight situation possible in the context of unhoused people?
Yeah, it's possible. Right now we have a preliminary injunction, which means that this order applies until the lawsuit's resolved on the merits. So there's a trial scheduled in the summer, and in theory the case could be resolved at that time, and then ongoing consent decree is a possibility, monitoring of some sort is a possibility. But at the end of this, if we prevail, there will be some order that ensures that the city has to comply with the Constitution when it interacts with people who are experiencing homelessness.
We've seen problems persist in those cases that have had consent decrees issued. Is there a reason to believe that a consent decree in this case would be effective?
Well, yeah, I guess I'm not. If there's a consent decree in this case, it would be effective because we would be monitoring and enforcing the consent decree. So, just the attorneys and the civil rights leaders who are involved in the case would make sure that the consent decree is effective.
Now, one takeaway that we had while reading Judge Allison's order is that the city must do something now, and that's unprecedented in the context of this issue in particular. I'm not going to ask either of you to offer a roadmap of what that might look like. It's not your job, Martha, that's the city's job, but what will this require in terms of a philosophical shift?
I think that the city needs to understand that it has a basic obligation to all of its constituents. That includes housed people and unhoused people alike. And as I mentioned before, nobody wants to live in a city where people are forced to live outdoors. It's in everybody's interest for the city to resolve the housing crisis. And to create emergency shelters that are only for emergencies, and in the meantime to create spaces where unhoused people who are forced to live outdoors can be and provide services.
Martha Mulvaney, Adam Flores, thanks so much for joining me on New Mexico in Focus.
Thank you.
Thank you.
You have access to economic development opportunities like banking. You have access to driver's licenses. It's a lot easier, even though New Mexico has a lot of immigrant-friendly policies. So, it's a different world and security. At the end of the day, even living in fear that you're going to be separated from your family and your friends and the place that you call home, having that sense of security that they can't remove you because of SIJS is, I think, huge when it comes to mental health of the youth and the families.
That interview with executive producer Jeff Proctor is coming up in a little over 15 minutes. Right now, we look inside a new book from author Rebecca Claren called The Cost of Free Land: Jews, Lakota, and an American Inheritance. It was published last week. Claren's book offers an intimate look at the long-term impacts of the Homestead Act through the lens of her Jewish family who received and benefited from land that they bought from the federal government after fleeing anti-Semitism and immigrating from Russia about 100 years ago. Our Land senior producer Laura Pasca spoke with Claren about those stories that she unearthed and about how the Homestead Act enabled millions of Americans, including Claren's family, to build wealth off of land taken from indigenous nations, including the Lakota tribe.
Rebecca Claren, I am so happy to have you here today.
It is amazing to be here. Thanks for having me.
Awesome. So your new book, The Cost of Free Land, interweaves the history of your ancestors, Jewish immigrants who were fleeing anti-Semitism in Russia at the turn of the 20th century, and the history of the Lakota people whose lands were taken away by the U.S. government. I have so many questions for you, but I wanted to start with, what did this project start as, and where did it take you?
In a way, this project started in the early days of my journalism career, which was 22 years ago. I was a staffer at High Country News. I was a young staffer there, and it was my first reporting assignment where I got to leave the office and not just report over the phone. And I went up to the Pine, or it was one of my first, I don't know if it was the very first, but it was one of the very first times I was on the road. And I went up to the Pine Ridge Reservation. I got to drive the company car. We didn't have cell phones back then, and we had this like burner phone that we brought with us, like we were drug dealers. And the book opens with this, but I was in the car with a Lakota man who was a buffalo rancher, and I was trying to make friends with him. I was very uncomfortable. I didn't know what I was doing. Yeah. And I tried to be pals by telling him, oh, my family used to be ranchers in South Dakota. We were homesteaders, thinking this would make him like me. And he was polite, but he was a bit cold. And it took me an embarrassingly long time to realize what, like, immediately that would have meant to him, which would have meant, well, your family got land that was taken incredibly unfairly from my ancestors by the U.S. government, breaking treaties that were signed between my nation and the United States. And so that's where this, in a way, that is the beginning of this story. And I've spent my whole career writing about the American West, basically, mostly for national magazines. I did write a one-off novel a few years ago, but that also was concerned with people and places that are the American West. And a few years ago, I was hired by an investigative nonprofit to write a series of stories about Native nations and Native citizens. And it was really when I was able to really just write only about Native communities intensely for a few years that I realized, oh, I am so uncomfortable pretending as a journalist that I'm just like an unbiased observer to this history and the legacy of these federal policies that are now playing out across Indian country in America. And because I have clearly benefited as a descendant of homesteaders from policies that caused great harm to Native people.
As the great-granddaughter of homesteaders, you write about how the land was taken away from the Lakota, how the federal government didn't just murder people, steal and abuse children, break treaties, and so much more. They also swindled Indigenous people out of their lands and out of the payments that were supposed to be held in trust. And yet white homesteaders, including your family, were able to leverage land into capital and wealth. Can you talk about why it is so important for us to continue reckoning with this 100 years later?
I love that question, because to me, it's really at the heart of this book, is to say this isn't history. This isn't something that happened in the past and that we have moved on from. I think a lot of the ways, at least the way I was brought up, I had excellent education. And yet the way I learned this history in school was very much, this happened a long time ago. And I feel very much, especially after learning from Lakota elders and studying with Jewish leaders, so there's sort of this cultural, more of a different cultural idea of time, but also it's just what is so true, is that the past, as I think Faulkner said this, the past isn't past, it's still happening. And that in a way, and I write this in the book, I feel like the past is looped to this contemporary moment like thread through a seam. And so to me, that was what was so important about this history, is that it's happening right now. And I used the way that my family was able to monetize our land to demonstrate in really stark economic terms, this is what this land in some ways has done for me, and what it hadn't done for Lakota people, because, to explain, I pulled every single deed on the land my family had. There were 6, my great-grandparents were homesteaders, my great-great-grandparents were homesteaders, and 5 of my aunts and uncles and their husbands and wives were also homesteaders. And they, over and over again, would take out a mortgage on the land. And you see, and I was able, because of like original family documents, letters, journals, newspaper clippings that I found from old papers, and then these documents from the deeds office, these mortgage payments, I could see this timeline that they would take out a mortgage on the value of their land, and then they would move, or they would start a new business that was not contingent on weather. My family got into the saloon business that was more steady in South Dakota than farming and ranching. And so you see these little bits of money, relatively little bits of money over time, is really what builds the pathway for them to become middle class and beyond. And at the same time that that's happening, the Lakota, as you said, are not allowed, most of them, to manage their own money. Their money is being held in trust by these reservation, sort of federal appointed mayors of the reservation, as they were called superintendents or Indian agents. And often they weren't receiving their money for a long time. There's documents of people dying of starvation while they're waiting to get their money and their payments off the value of their land that the federal government is supposedly keeping in trust for them and keeping track of. And so you see the disparity. And this is not where my own personal family then completely cross-sects with collective history and collective effort. Sociologists at this point today have connected a person's ability to own a second home, to pay for college, to have wealth, to the Homestead Act. The Homestead Act, legal scholars have called this a massive affirmative action for white people, the Homestead Act was. And there's something to like 25% of Americans living today, adult Americans, descend from homesteaders.
The second chapter of your book is titled The Holocaust at Home, and the use of that word is clearly deliberate, coming from a Jewish writer. Why is it important for us to use that word?
So when I was a kid, I was obsessed with the Holocaust. I now have a kid who's obsessed with the Holocaust, and it's totally unnerving. But I was also like, I wanted to read everything I could get my hands on. I thought I knew a lot about the Holocaust. And yet it wasn't until a Lakota elder who becomes really central to the project, and to me personally, Doug Whitebull, told me, your family, the Jews, they survived a Holocaust. It was horrible, but he had a Holocaust here, and it lasted for 400 years. And no one ever talks about it. And yet when you're in Lakota country, people talk about the Holocaust that happened to them all the time. The way, and I've learned through Doug telling me about it, and then going off and studying and reading books that by many scholars that were written about this, that in fact, Hitler and his legal team based many of their policies on how to restrict rights from Jewish people based on the way America was taking rights from Native people and Black people in this country. That blew my mind. And the fact that, again, it's one of these points where you think you understand. I thought I understood American history and more global history, and suddenly everything I thought I understood was really shaded when seeing it from this Native perspective. So yeah, I use that word very intentionally because that is the way that many Lakota elders who I spoke with talk about it. And I think it's reasonable. Children were murdered. People were starved intentionally to be controlled by the federal government. And they were restricted onto reservations, which Hitler himself used as a premise for concentration camps.
Right. So You also write in your book that America has failed to undergo any process of national truth-telling, reparation, or reconciliation, let alone any real public amends, and that clearly needs to happen in this country. But as you found and as you write, there are also ways for families and communities to be making reparations and reconciliation. I'd like to hear more about the work that you and your family are doing, but also the community work that you've been doing with Rabbi Benjamin Barnett.
Early in this process, an indigenous judge, Judge Abby Abenanti, who's the Chief Justice of the Yurok Nation, and she's also a former California Superior Court judge. She's a total badass. And she's like in her mid-70s. She's been doing this work her whole career. She was the first Native American, I think, the first Native American to pass the bar in California. She runs her courtroom for the Yurok Nation with an eye towards how did we do justice before cultural interruption. And it's all about, she says, and what she's taught me is justice works best when it's embedded in your own culture. So early on, but before this was even a book, when I was just thinking about it, she said to me, if you want to look at this history and you want to grapple with how to respond to this history, you need to study the Jews. What do the Jews say about how to respond to a harm? Maybe one you didn't directly cause, but one you have benefited from. And that I had a bat mitzvah. I belong to a synagogue. I light candles every week with my family to do Shabbat, but I had never done Torah study. I didn't really know how to do that. And luckily, I didn't have to do it alone. My rabbi here in town, Rabbi Benjamin Barnett, who cares deeply about social justice, my synagogue is a community of people who care about social justice, said, let's do this learning together. This learning will benefit our whole community. And so we spent several years studying ancient Jewish texts and contemporary rabbis who are writing and inspired by these ancient texts to consider what one rabbi in particular said is the sort of foundational sins of our country, that built our country, which is the stealing of native land and the stealing of enslaved people's bodies. And so I'm answering this in a very long roundabout way because it's very important to me that what my family is doing to respond to the reality of our history in America is grounded deeply in this Jewish learning that we did. And also, at the same time, I had many conversations with Lakota elders and asking them, what would be an appropriate response? What would work for you? And it took a long time. It wasn't until a couple years into my relationship with Doug Weipel, when I had asked this question a couple times, did he actually finally respond. And what Doug Weipel was a veteran teacher. He was, and he is like a teacher. He never really says, this is what you should do. He sort of just leads you to make connections on your own. And he said to me, he reminded me again of that's something he told me about before, which is there's a native-led effort to buy up when private land comes up for sale in the Black Hills of South Dakota. There's a native effort to buy private land, and that is held in trust for all Lakota people to use for ceremony and other purposes. And even the U.S. Supreme Court, there's no debate. The Supreme Court in 1980 made very clear, we stole this land. We unfairly stole this land from Lakota. And there's a lot of money sitting in a bank account that the United States said, here, we're going to pay you back because we shouldn't have taken this land from you. And the Lakota don't want it because they want the land instead. So this is a long way of explaining that what my family has done is I have started a fund called the He Sapa Recovery Fund with the Indian Land Tenure Foundation, which is the nonprofit that's Native-led, that's been doing this work for 30 years. We're not inventing anything here. And I think that's very important. I think that as descendants of settlers, you don't want to just be like, I've got the solution. I'm just following the guidance of something that Native people are already doing. And so we've created a fund, And I've set as our fundraising goal $1.1 million. $1.1 million is not a hypothetical number. It's the number when you adjust for inflation. When I culled all those mortgages that my family received from 1908 to 1960, I think is maybe the last mortgage we got. I made Excel spreadsheets. I adjusted for inflation. I had math nerds check my math, and $1.1 million is the amount that we received off that free land. And of course, we had to pay that money back. And of course, my family worked so hard and really struggled on that land. But to me, that money, it's what we owe. It's our piece of this.
Well, thank you, Rebecca. I loved your book. I learned so much, and I look forward to seeing where this book goes out to, and I'm sure tons of people will read it, but I also hope to see it in classrooms all across the country. But thanks for joining me. I appreciate it.
Thank you. Great to be here.
To hear more from Claren about her writing process and how to do some of that same research yourself, visit the Hourland channel on YouTube. A new law is expanding the age range for young immigrants to access green cards, work permits, and other benefits if they had been abandoned, abused, or neglected. Governor Michelle Lujan Grisham signed off on the law this spring after years of advocacy work from the New Mexico Immigrant Law Center and other groups. The state law now reflects federal immigration law, allowing people 21 and under to apply for special immigrant juvenile status. The cutoff in New Mexico had been 18 years old, with few exceptions. This week, executive producer Jeff Proctor speaks with an attorney from the Immigrant Law Center and a policy director from Bold Futures NM about the process of getting the law passed and how this bill could impact the lives of those 19 to 21-year-olds.
Jessica, Hasmin, thank you both so much for joining me on New Mexico in Focus.
Thank you so much for having us.
So as we just heard, the two of you were sort of the tip of the spear in getting House Bill 15 through the New Mexico legislature earlier this year. And we'll get to that experience in a moment. But let's start kind of with the lens wide open. The bill expanded access to what's called Special Immigrant Juvenile Status, or SIJS. Jessica, let's start with you. What does that designation mean legally in the immigration context, and who makes the determination in terms of who qualifies?
Yes, so Special Immigrant Juvenile Status, or SIJS, as you pointed out, is a special form of humanitarian relief designated by federal Congress since 1990 for immigrant youth who are abused, abandoned, or neglected by one or both parents, and where reunification with the parents isn't viable. And so under this process, it's a unique intersection of federal and state law where they have authorized the state to issue those findings of abuse, abandonment, and neglect. So we go to the state court process first to obtain an order that, with all of those requisite findings, once we obtain that order, then we proceed with the immigration phase of the case, which is then to proceed with the process for special immigrant juvenile status, and then that will ultimately give them protection to remain in the country, being in a more stable environment here in New Mexico. And then it ultimately it includes a pathway to permanent status and citizenship. And so it's a very special, unique form of relief that we're proud to work with immigrant youth across the state in trying to make sure that they know about it, are educated about it, and see if we can actually assist them in making sure that that can happen for them.
So in the end, it's a state court judge who makes that determination.
The state court judge makes the determination of abuse, abandonment, neglect, but it is only within the authorization of the Federal Immigration Agency to give the grant of the status. And so that's a separate process.
Gotcha.
Yes.
Hasmin, those three words that Jessica just mentioned, abuse, abandonment, and neglect, do those have special meaning in this context? Is there a particular set of criteria that goes into making that finding, or are they as straightforward as what we think they are?
No, and interesting you should bring that up. The bill actually addressed abandonment and how we wanted to support the court's decision in expanding what was considered abandonment. But, within the family law context and even within child welfare, there are very discrete definitions that judges and federal agencies and state agencies follow when we're talking about abuse, abandonment, or neglect. And I think one thing that we always talked about at the very beginning is, what does this mean when the goal should always be family reunification? And so we'll see a very interesting landscape where in these particular situations, you have a traumatic experience where the reunification isn't something that's viable. And so from that, you can obtain this type of status.
Let's stay with you for a minute, but I would like for both of you to respond to this. I'd like to talk about some real life experiences without, in some instances, of course, naming names, but what doors does SIJS open that had previously been closed? What are the benefits of obtaining that status?
Oh my goodness. So one of the reasons why this was very important for us was because of all the opportunities that it brings, right? I can speak personally to what happens when you don't have access to SIJS. I was 19 when I learned that I would have been eligible. In my particular family situation is that I grew up with a single mother and my father was absent, and there was absolutely no way that there would ever be reunification because my father just wasn't in the picture. But had I gone through the process, I would have been able to obtain a work permit. I would have been able to eventually obtain a green card and a pathway to citizenship. But even from the point of submitting an application and receiving a letter from the federal agency that's processing that application for SIJS status, you're eligible for healthcare like Medicaid. You're eligible to better navigate education, which was incredibly difficult for me as an undocumented person, and even trying to get my law license still undocumented. You have access to economic development opportunities like banking. You have access to driver's licenses. It's a lot easier, even though New Mexico has a lot of immigrant-friendly policies. So, you know, it's a different world, and security. At the end of the day, even living in fear that you're going to be separated from your family and your friends and the place that you call home, having that sense of security that they can't remove you because of SIJS is, I think, huge when it comes to mental health of the youth and the families.
Jessica, prior to passage of House Bill 15, who was eligible for this status?
There was a limitation, again, because of that intersection of state and federal law. Under state law, we were only able to obtain court orders up to the age of 18 based on the limitations of court jurisdiction. However, under federal law, the federal regulation allowed for immigrant youth to obtain this form of relief up to the age of 21, as long as the state law reflected that. And so it seemed like a very easy fix, although, you know, it was a challenge to get it passed, but that's what changed. We were now able to expand that eligibility all the way up to age 21. And it also, within that law as well, we were also able to expand what abandonment means. And so a lot of the youth that we would work with, that especially in rural community, we would talk to them and we would realize they met all of the qualifications, but unfortunately their 18th birthday was a week before, and so they were aged out of the system. And then there would be cases where immigrant youth were like, well, is there any way that you can make an exception for us? And there was only rare exceptions where we could help someone that was still in high school up until the age of 18. But at least now we're able to meet with them at beyond the age of 18 and have giving them at least a 3-year cushion so that we can actually apply for this form of relief.
So this was not a mystery. You knew from the very beginning that the way to fix this was to make state law match federal law.
Correct.
When did the work begin? When did the conversations begin in trying to get state law to reflect federal law in this way?
Yeah, so even before I became an attorney at New Mexico Immigrant Law Center, our office had been working for 2 years with different law students across the country talking about this issue, trying to find a way to see how we could change the policy to reflect the federal law. But again, we're immigration attorneys. The capacity to do that when we have wait lists and we have so many different cases going before us. When I came on board, you know, my supervisor, Monica Newcomer Miller, who's really taken the leadership in a lot of that robust bill drafting, she turned to me and she said, you know what, it's time, like, you know, would you consider this? And it was always my dream to become a movement lawyer. So I said, absolutely, let's work with community, you know, under, you know, with mentorship from Hasmin as well. We worked with community, did listening sessions. We developed notes and figured out that based on what community's direction was, that there were a lot more gaps to be filled beyond that age gap. But there was actually gaps in how the law was applied in terms of what is abandonment, and also that there would have to be an emergency clause so that we don't run against the clock again when we pass the law. And so it was a long process, but eventually through that listening sessions, I think that's where we really developed the strength of that bill. And that is what created the movement and the spark for why the law actually passed.
So once you had done that work in community, the listening sessions, you had identified a bill sponsor. Now it is actually time to take what you'd gathered from community and go in front of the Socratic wonder that is the New Mexico legislature. Can you talk some about what the experience was like once you got to Santa Fe? What was the experience like during committee hearings, floor debates? Put us in the room. How did that work?
Yeah, that's legislative advocacy is a difficult space to be in for anyone. I think, almost everyone in our state and across the country knows that we're the only legislature where our electeds are not paid for their time. So that is a challenge in and of itself. It's a challenge that these are systems not necessarily made for people like us, people of color, youth, immigrant communities, people who have been criminalized by various systems and are afraid to navigate these spaces. And then you have people like us who are part of the community. We look like the community, even though we're lawyers and have these fancy titles. People look at us and they also see our community, which is great for our community to be seen in those spaces. It is also challenging for us as leaders to walk into the spaces and not be afforded the respect that anyone should have walking into the state legislature. So it was challenging, but I think the beautiful part was that movement building that Jessica talked about. When we showed up to the Roundhouse, we didn't show up alone. It wasn't just the NMILC, it wasn't just Bold Futures and the other organizations that supported this. It was the community. We showed up together and in strength and numbers. And if there's one thing that I think our legislative officials really look to is, who am I serving and are they in the House? And our community showed up, and any time that we were preparing for committee, there were calls, there was follow-up, they would show up to the Roundhouse. And even after being on session floors, whether it was a House or the Senate, people were there. And once it was passed, there was this huge sense of relief. Like, people were running through the halls, across the hall from one chamber to the other. I know Speaker Martinez and his whole office ran to the Senate chamber, and we were all crying and hugging, because that was the beauty of being there together and in community, because it was a whole movement.
So the bill passed by really wide margins, right? It passed, I think it was 64-0 in the House, right. 33-6 with 6 Republicans voting against. On the Senate side, I'm not super interested in the margins really, but I want you to talk actually some more about how community overcomes resistance. How did that work in this context?
Yeah, I think, Hasmin really hit the point, is like we built power in community. It's about building power with the people rather than power of the law. And so when you have people collectively using all of our positivity, all channeling all of our own, strength, hope, faith, all of it, you name it. There was one particular client that was in the listening sessions that said, if there is only 1% chance of hope, I have 99% chance of faith. And we would read that to each other all the time, because there were moments where we were facing racism, microaggressions, in those spaces. And then at the same time, we were building allies with so many leaders that we have elected, and that we are proud to say that they've stood by us for something so important, because there was a sense of urgency. Like, people could be removed from this country without this form of relief. People need stability. And these are children, ultimately. This shouldn't have been as contentious as it was. But at the same time, when we realized that there was a movement building, that all of us were collectively coming together, you saw that every single hand that touched that bill made sure that bill made it through. And we all worked until the very end. I mean, we passed within 45 minutes of the session closing. And if you see on camera from that public record, you'll see that, I'm literally in tears once the bill's passed. I'm embracing with some of our Senate sponsors, as well as one of our state representatives that was there seated next to me. And then as I walked across, there was people coming, like she said, running across to give each other hugs, impacted youth who were calling, impacted youth who were coming to hug and embrace in the hallways. Legislative aides running and just cheering, and we left no stone unturned. We did what was considered impossible, to pass a bill the first time with not even doing interim session. So there was a movement, and at the same time, we were hearing from some of our attorneys who were in our team that did a lot of work behind the scenes, that they were there with their children who are 10, 15, 12, and they're letting their children watch this process, and they themselves are moved that this could happen in our state, and that they, some of them had the privileges that some of the immigrant children do not have, and that we were able to do something pretty much impossible at the last minute. And it was able to happen with leadership and people collectively coming together to build a movement. And that's what's beautiful about it.
Did y'all know the governor was going to sign it, or was it pins and needles for the couple of weeks?
Last session was heavily on child welfare. And so that's one of the reasons why the bill was able to move forward as House Bill 15. It was originally Senate Bill 229, and Speaker Martinez supported in his office in creating an emergency bill. But to answer your question more pointedly, one thing that a lot of people in policy advocacy, especially at the legislature, will tell you is it's not over till it's over. So even if a bill passes, even if you've gotten indications that it'll make it through, it is not through until it's signed. So we celebrated, we were happy, we slept a little, and then the following, week and the week after, it was still heavy mobilizing, ensuring that it would get signed. And once it did, I kid you not, the ink hadn't even dried. They sent us the picture on our phones and cases started getting assigned left and right. But it wasn't until it was signed and the news was shared and we were calling other agencies like Santa Fe Dreamers Project who took the first case that we knew, oh, the bill was passed. We can start assigning these cases now.
That's a great transition. And I would like for you both to weigh in on my last question, which is, now that House Bill 15 is the law of the land, what is the work ahead and how's it going so far?
The work ahead is we're in full thick of implementation. So we're working with the Administrative Office of the Courts and judges, doing trainings about this form of relief and making sure that we're educating about the law itself and how it's applied, as well as working with community across the state to see if we could reach more impacted youth and educate about whether or not they can qualify for this form of relief so that we could reach more people through referrals, as well as just working with other coalition partners, NMLC and SFDP and other private attorneys that work on these cases. We meet monthly to make sure that we are addressing all of these different templates and also trying to make sure that we are all on the same page of doing continued learning education classes so that other attorneys are aware that this is a new law. And so we're continuously trying to run against the clock here and trying to get as many youth before they age out into 21 now. And just also really trying to do the education piece and doing town halls with community so that they're aware that if anyone works with community, please contact an attorney, contact our office or any of the other offices so that you can get a consultation. That's really important.
And in addition to all that, you're taking cases, right?
Right.
Gotcha.
Right. And what's powerful is that, I guess, again, with this form of relief, we're able to actually assist with defense of the removal case. And if they qualify for this form of relief, this prevents them from being removed from this country. And there is actually stability, and this actually benefits their overall well-being beyond just the generational impacts of access to permanent status and citizenship. And one thing that we were both talking about yesterday, that if there's one way we could just pinpoint what HB 15 really was, in the words of Claire Dudley Chavez from the Speaker's office, she said it was a little bill that could. It truly was, because we saw how it went through so many obstacles, but through community power, it was able to pass.
That's a great place to end the conversation, though I know we could go on and on. Jessica Hasmin, thank you so much for coming down today.
Thank you for having us.
Thank you to Jeff and to all of our guests who made time to speak with us for the show this week. We end tonight with a new development in the redistricting lawsuit filed against the state legislature. The Republican Party of New Mexico is appealing a decision from a state district court judge who ruled that the Democrat-controlled legislature's congressional boundaries do not violate the state constitution. That's despite the judge acknowledging that the redistricting diluted Republican voting power. At particular issue in the lawsuit is CD2, a swing district that in part skirts the U.S.-Mexico border. In 2022, Democrat Gabe Vasquez narrowly defeated first-term Republican incumbent Yvette Herrell by less than a percentage point. Judge Fred Van Solen ruled that while the plan from the Democratic lawmakers watered down the GOP's chances, they did not egregiously gerrymander. He says there isn't enough evidence that the redrawn districts unfairly secure long-term power for Democrats. This ruling is sure to make a splash on the national stage, as Republicans aim to maintain their slim majority in the U.S. House after the upcoming 2024 elections. CD2 has seen some of the tightest races in the country during the last few election cycles. Right now, Democrats hold all statewide elected offices in New Mexico and all 3 congressional seats. The next stop for the GOP's case is the New Mexico Court of Appeals. Thanks for watching. We'll see you next week.
Funding for New Mexico in Focus provided by the viewers like you.